Thank you, Mr. Chairman. It's rather sad, in my opinion, to have to rise in the committee stages in this body, which is the highest body in our democracy, the most representative body, and to give what is in effect a primer on the nature of democracy and democratic decision-making, because democracy is fundamentally violated by this bill. Democracy is not about giving a minister the power to override the decision-making of local bodies. And that is exactly what the explanatory note in this bill says. It says the minister has, quote, the ability to suspend, amend, cancel, delay any council plans and policies, end quote. It's very definitive, and that sums up the bill in that respect. Councils, it is true, have a consultative role under this bill, and the SOPs being moved by the Green Party trying to extend the extent of this consultation, the extent of the community engagement required under this bill. But consultation cannot substitute for people at the local level actually making decisions through their local representatives about their future as a community, as a city, in this case in Christchurch. And the reason, apart from, we'd like to be democratic, that local bodies should have this power is that local people actually know better than any bureaucrat from Wellington or anywhere else what is important to their future. And there are absolutely vital decisions to be made over the next while, particularly over the next 5 years in the currency of this bill, decisions to shape the future of Christchurch, their city, not our city sitting here in Wellington. And these decisions must be made by the people of Christchurch, not by a minister or a bureaucrat residing here. Now, does the central government have a role? Absolutely, it has a role to assist the people of Christchurch, not to control the people of Christchurch. And our assistance is to give the resources to help speed, to streamline the process of recovery, rebuilding, etc. And yes, enable shortcuts to be taken through certain bits of legislation. The Greens oppose that. We agree that with parts of the bill whereby modifications are allowed to particular acts to achieve more rapid recovery than would be normally the case through existing statutes. But to achieve that, we don't need to give power to the government to override most of the laws on our statute book. And as one of the submitters to the Select Committee has said, David Bullock and Daniel Jackson, they say it overrides a whole range of acts, including the Human Rights Act, the Crimes Act, the Habeas Corpus Act, the Official Information Act, the Ombudsman's Act, and they go on and on. There is absolutely no reason for those acts to be overridden. And the overriding of acts is not effectively constrained by either the law courts or by Parliament. And while there is some right of review, it is not effective in a legal sense. And of course the Law Society in their submission to the Select Committee wanted much more reference to Parliament whenever laws were overridden, and some of the Green Party SOP's amendments to this bit of legislation try and put the power back into Parliament to a greater extent. Now, is having a czar in the form of a minister to direct the recovery of Christchurch, is that more efficient? Is this sort of state of emergency? And it is true that with emergency powers, sometimes things can be streamlined a bit better, and we've had a series of weeks of a state of emergency which have helped in the recovery of Christchurch to this point. The Green Party has supported those orders, but even when you look back at the history of that, while there are advantages to that, there are also disadvantages. In turn, you can just note the complaints as late as this morning on Morning Report of people, business owners and that, who haven't been able to get into their offices in the red zone, into the CBD, to recover even basic items, computers, files, etc. Day after day there have been complaints like that, whereas outside the red zone, where there isn't the same application of constraints, people have been entering dangerous buildings, taking calculated risks, Mr. Chairman.
Keith Locke.
And retrieving their files, etc., inside whereas the bureaucrats in the red zone have been ultra-conservative in their risk assessment and just taking no risks whatsoever of any danger and causing, in the process, a great amount of angst amongst business people, workers, depression, all sorts of things like that, a result of this avoidance of risk, which is a characteristic of people who have absolute power and are not necessarily so in touch with the local situation. Now, communities do have huge resources and abilities to address these problems. These are being underestimated in this bill. In the suburb of Sumner, for example, a fantastic example of people getting together, all sorts of subcommittees, the liver services, social events, you name it. It's been and the student volunteer army. It just shows that the capacities of local people can be unleashed if you allow them to the initiative. And I think the people of Canterbury do have the capacity to come forward with the plans, to implement the plans with the assistance financially and in terms of resources put in from the central government level. And we have had a lot of discussion here about the Constitution and constitutional restraints, etc., etc. It's useful just to refer to why we have them. Now, often it's people say, oh, well, you know, so far we haven't done too badly and we should trust the Minister, Jerry Brownlee. He's a good bloke and he wouldn't unnecessarily override constitutional provisions and acts and etc., etc. But that is not how... Why we have these constitutional restraints is that we don't trust anyone in the executive as such. You know, that we have these because people don't always do the right things. Well, it may be we have a dream run with Jerry Brownlee for the next whatever, but we should write laws not according to the trust in a particular person or a particular government of the day or whatever, but what is constitutionally right and what is basically democratic, and writing off the appeals to courts and the validation of actions by Parliament is not the way to do that. Now, I think the process of urgency here is another illustration of the problem with this bill. You know, we didn't need to go to this rapid, doing the bill over 2 days, not knowing what the bill was till a couple of days ago, not knowing what the government's amendments are even now, partway through the committee stages. All we needed to do, and the Green Party proposed this and stressed this, just extend the state of emergency a bit longer and have a few weeks to have a proper select committee process. It could have been done, it should have been done. There's absolutely no reason why it wasn't done. And now we're in probably the biggest mess I've ever seen in my time in Parliament, you know, discussing a bill without the government amendments, which are probably fairly numerous, before us, most of the way through what was planned to be the committee stages. You know, that's absolutely unacceptable, and I think the fact that the government would do this, would force this urgent process, not allow people in the community proper time to come forward with their amendments, their changes, just shows how we can't, you know, the need for constitutional restraints, the need not to just trust this government or any government on such matters. The select committee process is vital in our democracy, and if you read the people who did, you know, even though the council only had the councillors, who some of them, you know, there's Chrissy Williams here, made a submission. She only just managed to, get hold of the bill before the select committee process, did a sort of a handwritten criticism of certain aspects of the bill. She's a city councillor. You have a process where even the city council, the body that's technically responsible for the recovery in Christchurch, although that's now being overridden by the government, even the city council like that didn't have access to the bill and be able to properly work out a response to it. It's just inaccessible. And as Dean Knight, one of the submitters, said, the legislative scheme is drawn in command and control terms. This is a very good submission, actually. Dean Knight, he's a law lecturer at Victoria University, and he goes through a bit like I have here, a whole... Thank you.
Nicky Wagner.
Mr Chair.